Hello, and welcome to the International Criminal Law Interest Group panel on Head of State Immunity for the 2020 ASIL Virtual Conference. My name is Andrew Boyle, and I am co-chair of the ICLIG Interest Group.
Hello, my name is Milena Serio. I just finished serving a 3-year term as co-chair of the International Criminal Law Interest Group, and it is really a pleasure to be here virtually.
We're very glad that you've chosen to join us for this panel. In this panel on Head of State Immunity, we're going to be talking about Head of State Immunity under international criminal law in light of the recent case law and other developments at international courts. Head of State Immunity, as you may know, remains a controversial topic within international criminal law. Although many scholars and tribunal prosecutors argue that sitting heads of state should not be immune from international prosecutions if accused of atrocity crimes, multiple states, as well as a minority of scholars, assert the opposite. In practice, the work of the International Criminal Court, as well as the work of other tribunals, such as the International Criminal Tribunal for Yugoslavia, have been hampered because of the assertion of head of state immunity. And moreover, immunity has been asserted by former and sitting heads of state within domestic contexts. Such immunity claims impede the pursuit of justice and the imposition of individual criminal responsibility. So without further ado, I'm going to one by one introduce each of our 4 panelists and give them an opportunity to make an initial short statement on the topic of head of state immunity. So our first panelist is Professor Adil Haque. He is a professor of law and the Judge John O. Newman Scholar at Rutgers Law School. His book, Law and Morality at War, was just released in paperback by Oxford University Press. Adil primarily writes about the law and ethics of armed conflict, but he's also written on immunities for just security and the Oxford Handbook of International Criminal Law. Professor Haque?
Thank you so much. So on the first day of class, we tell our students that states make international law. And at some point in the semester, we tell them that the rules governing immunities are very, very important. And yet states have largely abdicated their responsibility for clarifying and developing the law in this area, with some notable exceptions. So the International Criminal Court issued its first arrest warrant for Omar al-Bashir, then the president of Sudan, in 2009. And everyone understood that the case raised fundamental issues about the content of customary international law, the meaning of the Rome Statute, and the legal effect of Security Council resolutions. And yet for 10 years, states largely left these questions linger and simply left their resolution to the ICC. Now, I believe that the court made the best decision it could, given the legal materials available to it. But the very fact that the court had to decide the issue on the basis of what I would consider somewhat meager legal materials reflects, I think, a failure of the international legal system as a whole. So going forward, my main plea is that states not repeat their mistakes and discharge their responsibility to clarify and develop international law in this area.
Thank you very much. Our next panelist is Professor Sadat. Professor Laila Nadya Sadat is the James Carr Professor of International Criminal Law and Director of the Whitney R. Harris World Law Institute at Washington University School of Law. She has also served as the Special Advisor on Crimes Against Humanity to the International Criminal Court Prosecutor since 2012. Professor Sadat is an internationally recognized authority and prolific scholar writing in the fields of public international law, international criminal law, human rights, and foreign affairs, and has published more than 100 books and articles in leading journals, academic presses, and media outlets throughout the world. Professor Sadat?
Thank you so much, Andrew. And it's a pleasure to be here with good friends and colleagues to discuss this. It's obviously a very important topic, and I'm glad to our audience if you are able to be with us as well. After the al-Bashir decision came down from the ICC last summer, I wrote a very short piece on just security edited by Adil Haque, actually. And I said three things about it. One is I thought that the decision was not surprising as a legal matter. And the reason I say that, which sort of shocked some of my international law colleagues, is maybe it's my age, which is why I've written so many books, but I was actually at the Rome negotiation and participated at the Rome negotiation in a different capacity than Ambassador Sheffer, obviously. But to my mind, looking at the International Law Commission's work on the question of head of state immunity, looking at the Nuremberg tribunal language about head of state immunity, there was nothing unusual really about Article 27 and its pedigree. Also, every international court that had ever looked at the question had concluded that heads of state did not have immunity before international courts. That obviously, that statement doesn't answer every question about the Al-Bashir case, but nonetheless, it's unsurprising to me, given the jurisprudence that we did have and given the negotiating history of the Rome Statute, as well as the sort of Nuremberg and pre-Nuremberg precedents, that the ICC Appeals Chamber came to the same decision, which I think was correct. Where the ICC Appeals Chamber made perhaps a stronger, but I think not only defensible, but very important leap forward in our thinking about jurisdiction and immunity in international law, is it held not only that the immunity had somehow been removed, it said there was no immunity to begin with. And that is a very important distinction. It sounds trivial, but what I think they were really saying is that at the international plane, what we're calling universal jurisdiction or international jurisdiction is something very different than what states are exercising as amongst themselves. So questions of interstate jurisdiction are very different than questions of international jurisdiction. I wrote that again 20 years ago in my first article on the International Criminal Court, which is why I found it both unsurprising, but I think it is an important distinction. There's not a removal of immunity. They're arguing there is no immunity with respect to these specific crimes. And I think that, so they may have gone further than they needed to answer the actual question. And I look forward to our conversation about this. Maybe I'll just stop right there. Thank you.
Thank you very much. Our next panelist is Professor David Sheffer. Professor Sheffer is Vice President of the American Society of International Law and is the Mayer Brown Robert A. Hellman Professor of Law at Northwestern University Pritzker School of Law. He's also the Tom A. Bernstein Genocide Prevention Fellow at the Simon Skilk Center for the Prevention of Genocide at the U.S. Holocaust Memorial Museum and a visiting senior fellow at the Council on Foreign Relations. He was the first U.S. ambassador at large for war crimes issues from 1997 to 2001 and led the U.S. delegation in UN talks creating the International Criminal Court. From 2012 to 2018, Professor Sheffer was the UN Secretary General's special expert on UN assistance to the Khmer Rouge trials. Professor Sheffer?
Thanks very much, Andrew, and it's a great pleasure to be with everyone today. I want to amplify a little bit of what Laila in particular said. You know, the Nuremberg and Tokyo precedents were obvious precedents for us as negotiators to duplicate, not only in the Rome Statute, but frankly in the statutes of all of the ad hoc tribunals in the 1990s. It was implausible to omit, as these are leadership crimes, the purpose of the ad hocs were to target precisely those who would claim head of state immunity, as well as functional immunity. When it comes to atrocity crimes, genocide, crimes against humanity, war crimes, the conventional explanations of customary international law simply made no sense when constructing an international tribunal. And the plurality concurring opinion in the ICJ's Eurodia decision a few years later nodded in the direction of that point. Well, during the tribunal building era of the 1990s, we were determined to break the mold that had been dented with Nuremberg and Tokyo, but we needed to lock in this principle. There's no question that the mold has been broken with the tribunals because these are atrocity crimes at stake, and it is simply implausible that one would build an international tribunal that would then shield the leaders who perpetrate the atrocity crimes. So the tribunal's jurisdictional reach is the essential issue when posed with a real case, like the Al-Bashir case before the ICC. But I just want to stress that any argument in the year 2020 that somehow would entitle a political or even military leader enjoying personal immunity under international law in the conventional sense, also being able to enjoy that personal immunity before an international court for commission of atrocity crimes, well, that argument lacks a fundamental premise in modern society. If the tribunal's jurisdiction regarding atrocity crimes reaches that leader, then bingo, head of state immunity fails, and we must conclude that it is an archaic concept that must fail under these very narrow circumstances. Now, as an original framer of the Rome Statute, and one heavily involved with both Articles 25 and 98 during years of negotiation, I was a bit surprised at the argumentation before the appeals chamber by Jordan and some amici trying in the final analysis to discover some preconceived intent on the part of the framers to create a scenario whereby a Security Council referral of a non-party state situation would have the effect of immunizing top leaders of the perpetrating non-party state from the reach of the ICC if they would just travel abroad and thus insulate themselves from arrest while abroad on state party territory. When one is negotiating the statute of an international criminal tribunal, one is constantly asking oneself, does this make sense? We cannot figure out all hypotheticals as framers, but we can grasp fundamental realities while negotiating. I just want to put down a few markers very quickly. It would never have occurred to me that Article 98.1 of the Rome Statute trumps Article 27, as that would not make sense if the court had jurisdiction over the indictee. In other words, head of state immunity would not be a valid premise for shielding the non-party state indictee from arrest on either his or her own territory or that of a state party obligated to cooperate with the court. The appeals chamber had the benefit of 22 more years of customary practice to confirm a customary international rule to that effect. But in the 1990s, I will admit that I was certainly more inclined as a drafter to premise the point with the Security Council referral of a non-party state situation than with a hard and fast rule of customary international law as of 1998, when the Rome Statute was concluded. And so I do put a bit more weight on those pretrial chamber rulings in al-Bashir that point to the Security Council referral, with all the powers of the UN Charter behind it as well, as the premise for denying head of state immunity to al-Bashir when he stepped onto a state party territory. But I also do not dismiss the notion that what the appeals chamber started or stated was true in 1998. It just was not dominating at least my thinking at the time, namely that, quote, and this is from the appeals chamber decision, there is neither state practice nor opinio juris that would support the existence of head of state immunity under customary international law vis-a-vis an international court, and that such immunity has never been recognized in international law as a bar to the jurisdiction of an international court. Now, just another brief comment. In my mind, it just would not have made sense to draft Article 27 and then eviscerate it because the UN Security Council referral is somehow less inclusive of the Rome Statute's most fundamental provisions. Otherwise, the Security Council referral is nonsensical, as any leader could evade arrest by simply leaving his own country to a state party territory, utterly defeating the intention of the referral resolution. As a framer, I have to weigh in that not only is Article 27 exceptionally powerful, it is powerful in the context of the UN Security Council referral as well. Its relevance would be worthless without the power of arrest to uphold it, and a state party's duty to cooperate after consultation is necessary. Let me conclude with this one very short point. The days of head of state immunity on atrocity crimes are limited. First, head of state immunity is implausible in these circumstances and so very challenging to civilized thinking. Second, my own just security essay in September 2019, I looked at the US president in this context. Under federal law, per the Department of Justice's memos that proved so important in the Mueller investigation, that theoretically it would seem that the president can commit atrocity crimes and get away with it, with only punishment possible after the president leaves office. Not even criminal investigations may be possible when he holds the presidency. At least that was argued. Does that make sense regarding atrocity crimes? that the US president could orchestrate genocide or crimes against humanity and face no liability in real time under US law other than through impeachment? That makes no sense, either in the US or elsewhere. So in that respect, I do embrace the Appeals Chamber's affirmation regarding the existence of a customary rule of international law in this respect, one that national laws should respect and implement. Thanks very much.
Thank you. And our final panelist is Professor Ingrid Wuerth. Professor Wuerth is the Helen Strong Curry Chair in International Law and the Director of the Cecil D. Brandstetter Litigation and Dispute Resolution Program at Vanderbilt Law School. She has written widely on many immunity-related topics and has served as a reporter for the Restatement Fourth of the Foreign Relations Law of the United States. In her role as reporter, Professor Wuerth focused on foreign sovereign immunity. Among many other honors, she has served on the board of editors of the American Journal of International Law and on the State Department's Advisory Committee on Public International Law. And she is also a contributing editor at Lawfare. Professor Wuerth?
Thank you so much, Andrew, for that introduction, and Andrew, both you and Melina, for the invitation to speak here. It's great to talk about head of state immunity and international criminal law. I want to step back a little bit and frame the conversation maybe a little bit more broadly. The immunity to which heads of states are entitled may vary depending on the type of court or the tribunal in question, and upon whether the defendant is a sitting or former head of state. And several of you have alluded to this. Most of today's discussion so far has focused on the International Criminal Court and the prosecution of sitting heads of state. There are other fora in which heads of states might be held accountable, and I think it's important to keep these other fora at least in mind as we discuss international tribunals, if for no other reason than many states are not parties to the International Criminal Court at all, to the Rome Statute. In the arrest warrant case, which David already mentioned, the International Court of Justice held that a minister of foreign affairs had the same kind of personal immunity that a sitting head of state enjoys, meaning an absolute immunity from suit in a foreign domestic court. Immunity of sitting heads of state before foreign domestic courts, I think, underscores the importance of accountability before international tribunals. Again, you can't, head of state immunity prevents the prosecution of sitting heads of state in domestic courts. Therefore, the important accountability function has to be played by international tribunals. There are other fora in which we might also seek some measure of accountability. The domestic courts of the defendant's own country, as David just referenced, practically speaking, this isn't very common or very likely, although it may happen after a head of state leaves office. Immunity is also not in play if the state which is entitled to invoke immunity does not do so or waives immunity. There are a number of cases involving former government officials in which states don't bother to raise the immunity defense at all. And then after a person ceases to hold office, that is, after a head of state is no longer head of state, they may be tried in a foreign domestic court, at least with respect to acts that are taken in a private capacity. On that last mechanism for accountability, the trial of a sitting head of state in a foreign domestic court after he or she leaves office, note that this type of immunity is not a personal one. It's what we call functional immunity or immunity rationale materiae. The International Law Commission has taken up this topic in a broader project entitled Immunity of State Officials from Foreign Criminal Jurisdiction. Those draft articles reaffirm the absolute personal immunity of sitting heads of state from foreign criminal jurisdiction. But they also provide that former heads of state are entitled to immunity rationale materiae with respect to the acts performed in an official capacity. But in draft Article 7, the ILC has said that this immunity does not apply with respect to certain crimes under international law, including war crimes, torture, genocide, crimes against humanity, apartheid, and enforced disappearances. So again, recall that we're discussing immunity before foreign domestic courts. And what this means is that draft Article 7 would allow criminal prosecutions in foreign domestic courts of former heads of state for the listed international crimes. Note that draft Article 7 also applies to other current and former officials, that is, anyone who is not entitled to personal immunity. I'll just wrap up by saying that draft Article 7 has been extremely controversial. It was controversial within the International Law Commission itself. And the primary argument against Article 7 is that it lacks support in state practice. And I'm happy to talk more about the kinds of state practice that point in various directions. So I'll leave it there and look forward to the discussion.
Thank you so much. And before we jump into the questions, I just wanted to throw in just a very short caveat here. According to the ACIL rules, a person cannot be on two different panels as a moderator and then a speaker. So because I'm actually going to be speaking as a last minute substitute, if you will, on a panel at the virtual meeting, I am acting as a, fake moderator here. So Andrew is going to be taking the lead and asking most of the questions. But because, both of us put in a lot of work into this session, I will ask, a couple of questions. So I'll start by asking the first question, and this one is for both Professor Sadat and Professor Sheffer. And it has to do with, we're really stepping back a little bit, and we would like to ask you why it is important for heads of state to be, in theory, held accountable for international crimes before international courts. What are we trying to achieve, or are we hoping to achieve through this notion of accountability? So Professor Sadat, would you like to start?
Sure. I was going to defer to Professor Sheffer, since he's already started to articulate some of the reasons why, right? That these are leadership crimes by their nature. This really came out of the Nuremberg experience and the pre-Nuremberg experience, which is that prior to the establishment of the United Nations, and really prior to the establishment of the Kellogg-Briand Pact and other documents that outlawed war itself, we had at the turn of the last century, the Great War, right? World War I, which was a war that resulted in tremendous casualties. And there was an effort at the end of that war to try the German Kaiser for his crimes. And that didn't go very far. The Kaiser spent a lovely exile in the Netherlands, even though there was a sort of, in the Treaty of Versailles, there was a provision in Articles 227 and 228 that would have permitted his trial. In fact, there really wasn't much stomach to bring him to justice. And the American members of the commission that had sort of debated this issue objected and said that a head of state could only be tried by his own people. And so that effort was unsuccessful. But meanwhile, the law, especially in Europe, continued to evolve. And I know this is sort of a roundabout way of answering it, but I think it's important. Because there was a sense that the old way of doing business was not successful, right? That having impunity, that we now call it, or having l'état c'est moi, that I'm the sovereign, and sovereignty means never having to say you're sorry, right, was simply an unsuccessful way of addressing the atrocity crimes. And it wasn't really fast forwarding until World War II that the sort of overwhelming magnitude of the Nazi atrocities in particular created a situation in which that law that was starting to be built up, even the failed experience of World War I, the Kellogg-Briand Pact, the 29 Geneva Conventions, the other law that was starting to come up on the books was sort of grabbed by the Allies, the United States in particular, right? And created a tribunal in which head of state prosecutions were not only envisaged, but were the focus of the tribunal itself. Remember that the Nuremberg Tribunal focuses its jurisdiction on those major war criminals whose offenses have no specific geographical jurisdiction. And so this was seen really as a response to the fact that the old way of doing business, the handshake, the impunity, was resulting merely in lots and lots and lots of casualties. And I think in modern times, we also can look to the fact that we've had the erosion of sovereign immunity, right? And immunities even at the national level, whether it's tort immunity or other kinds of immunity. Accountability is simply a useful thing. And the lack of accountability, whether it be in a domestic system or at the international level, leads to abuses and abuses of power. So I think I'll just stop there. I think David Sheffer probably has a lot to say about that question.
Well, thanks, Laila. I'm so glad you went first.
Oh.
You really laid the groundwork perfectly. I was thinking in my mind initially, Kaiser, but now you've done it. But I will say that in the 1990s, during what I would call the tribunal carpentry era, when we were building these courts, and that includes the Sierra Leone court, the Cambodian court, as well as Rwanda, Bosnia, and of course the ICC, we knew in every single exercise that the direction of the atrocities was a leadership from the very top of the pinnacle exercise. And so it simply was a force of necessity that head of state immunity had to be eliminated from the statute as a defense or as an exclusion of certain individuals from the jurisdiction of the court. No, those individuals had to be part of the jurisdiction of the court. And frankly, even in the earliest operation of, for example, the Yugoslav and Rwanda tribunals, as well as, for Pete's sake, the Sierra Leone tribunal and the Cambodia, I mean, all of them were premised on going after the head of state and the top ministers because they were the triumvirate of evil in each of those societies. So it really was a reckoning for head of state immunity, and it was just logical to build that in. And for the ICC itself, yes, it's a struggle, but remember, that's a treaty-based organization. So as a state party, if you sign on to it under the Rome Statute, you are embracing a concept that you may not like because you like to have political relationships with all sorts of other countries, some of which have committed atrocities against their own people, and you want those political relationships. But at the end of the day, it is the treaty itself which is binding you to this principle of non-immunity.
Professor Wuerth, if I could ask you a question, which is in terms of the normative reasons for immunity, could you speak to the difference between domestic and international prosecutions? And maybe in the context of that, also talk about how those ideas might intersect with the idea of universal jurisdiction?
Yes. Terrific. Thank you, Andrew. Yeah, it's it's interesting to think about what value immunity has at all. Why it's a thing? Why is it ever a thing? It's not very attractive to shield sovereigns from the bad stuff that they do, and they do lots and lots of bad things. If you listen to some people in the United States, for example, China has released COVID-19 on the world and should be held accountable in the US for that. That proposition has created a lot of fans of immunity. People who don't like immunity in other contexts have suddenly found themselves very enamored of immunity when we start thinking about civil suits against China related to COVID-19. That's a very far cry doctrinally and intellectually from international tribunals. But I do think it's helpful to think of immunity generally, and if it's ever appropriate, why and what is it doing? And so some of the values of immunity that have been put forward, particularly in the context of immunity before foreign domestic courts, are the basic sovereign equality of states, a basic respect for other sovereigns. A second reason that's often given, particularly for head of state immunity, again in foreign domestic courts, is a need for communication, a need for travel, a need for discourse, a desire to have countries interact with one another. It is difficult to do that if sitting heads of state fear foreign domestic prosecutions. Another concern that is reflected in immunity, I think, is a concern that some foreign domestic courts may just not be a great place to try international crimes. That is, when we lift immunity in the domestic court context, we're lifting it everywhere for everyone. And as nice as it is to think about how great it is to have atrocities tried in Belgium and atrocities tried in Germany, we might feel differently if those cases were in Iran. We might feel differently if those cases were in Israel or the United States. And again, we have, I think we often have a vision that the countries that have very broad universal jurisdiction statutes tend to be the countries that engage in these prosecutions, and generally they have terrific justice systems, and generally they're staffed with terrific people, and they further these values of accountability. But remember, the doctrine is not limited to countries that you or I think are fair, or that you or I think is a good place in which to try a crime. There are, I believe there is less and less consensus globally about who has the soft power and who has the moral high ground. So I just think if 20 years ago there might have been a consensus that Europe was a good place to try these, or perhaps the United States with the civil side, with the Alien Tort Statute, I think a lot of that's gone. And so I would just put that out as a background. Now, I think most of that speaks in favor of trials and a lack of immunity before international tribunals, because they don't share this particular set of most of these disabilities. I guess I would just say, to the extent we push the envelope on state consent, and we start taking actions in the territory of states or against the officials of states whose consent is questionable, I think some of these general issues begin to resurface. And that isn't an opinion on any particular case. I'm just talking about the value that immunity serves. And I think the value of immunity is actually heightened today in a very, very polarized world. And I think we need to be very careful about the values that it protects. So I don't want to go on and on. Everyone will have different views about this, but I do think that international tribunals are very differently situated from domestic courts, and that immunity has a much more important place in foreign domestic courts. On universal jurisdiction, universal jurisdiction, immunity, the obligation to extradite or prosecute, those are three really great topics that we could spend a very long time unpacking doctrinally, probably without a lot of agreement. Let me just say about universal jurisdiction. Doctrinally, universal jurisdiction is a doctrine of prescriptive jurisdiction. And immunity is a doctrine of immunity from the adjudicatory power of a tribunal. And that's not to say there's no relationship between the two, but doctrinally they do actually go to quite different things. And they are also distinct from the obligation to prosecute or extradite. Now, in a system of universal jurisdiction, or in a situation in which you have an obligation to prosecute or extradite, it is true that immunity might make those other mechanisms much more difficult to put in play, right? So why bother having why bother requiring under the Convention Against Torture to prosecute or extradite if, on the other hand, you allow a state to assert immunity? It seems like that the immunity makes no space for prosecution, the responsibility to prosecute or extradite. I'll just say in practice that actually hasn't been the case. It is interesting the number of countries that don't actually assert immunity on behalf of their officials. And just remember, it is the state's immunity, not the individual's immunity, and it is the protection of the state itself. And we actually have a lot of prosecutions of low-level officials where the state's like, meh, we're a new regime in power. Go get them. Or yeah, they've absconded. They've left Syria. Now they're in Germany. We're happy that they're in jail. We don't want them running around making trouble. So I think the factual claim that to have universal jurisdiction or prosecution or the responsibility to prosecute or extradite, you must get rid of immunity. Factually, that's just not true. Although there are tensions between those doctrines, to be sure. So that's gosh, I've said way too much. I'm so sorry.
Professor Haque?
Just a quick point, reacting to what Professor Wuerth just said. This is actually, I think, one of the reasons why the ILC's current discussions about the procedural mechanisms by which immunity is either asserted or waived is actually incredibly important. Because if the default is immunity applies unless it is waived, then these Syrian former officials currently under prosecution in Germany have a different status than if the presumption is there's no immunity unless it is asserted. So these procedural mechanisms actually become incredibly practically important. Those debates are still ongoing, so I encourage folks to follow them and get involved to the extent that they can.
Agree 100% with what Adil just said.
Thank you.
And maybe just to draw one other connection. Oh, sorry. Professor Sadat,
well, I was just gonna maybe just a one finger, and then if that's okay. I think what both Adil and Ingrid are suggesting too, and you see this in the ICC litigation, is that there's a certain degree of contestation of the courts themselves, right? If you look at Jordan's pleadings in the al-Bashir case, it all sounds extremely procedural, except really underlying the whole thing is a critique of the ICC as a legitimate forum at all for the exercise of jurisdiction over heads of state, even with the Security Council referral, which clearly contemplated, right, that it could be one of the troika, whether it's not the head of state, it could be the foreign minister or some other head of government. And so I think one has to recognize that there's a certain contestation of the legitimacy of the forum itself, which is why this is bubbling up to the fore and why it's not just a purely legal question. I think it's taking on a certain political and fundamental conversation about the legitimacy of international law and international institutions generally. Sorry, I didn't mean to interrupt, Adil.
So
thank you. That's actually a great segue to the next question, which was for Professor Haque, and which had to do with the al-Bashir, with the appeal judgment in the case of al-Bashir, the Jordan case. So if you want to actually, answer very briefly Professor Sadat's, comment, and then tell our audience about that case and whether you think that case was correctly decided, that would be great.
Sure. So first, just in response to what Professor Sadat just said, maybe I'll just put it to the group. Then how do you see the role of the Assembly of States Parties when there are some states parties who I think you're right, are trying to really make the court a much less effective institution than perhaps, as David suggested, it was originally designed to be? Why don't we see more explicit discussion, debate, pushback from states who want the court to be a more robust institution? How can it be that we have a sitting body that can clarify the meaning of the statute, and yet it doesn't seem interested in doing so? How should we understand that, non-engagement from the Assembly of States Parties?
I think, well, having attended most of the ASP sessions, the states that are the most vociferous, right, are the non-states parties. So of course, they're not really coming to the ASP to ask to change the law. Yeah. There was an effort by the AU, and it wasn't really by the AU. There was one state that suggested, for example, there should be an amendment to the statute allowing the General Assembly, not just the Security Council, to stop a prosecution. There's been very, very little appetite, and that wasn't seconded by any other state in the ASP. So what I'm seeing is a big difference between discussions at the AU level, and maybe David Sheffer might have a different view, but I go to these conversations. The ASP feels this is the job of the court. This is the job of chambers, actually, to articulate the law. It's not the politics. And the politics within the ASP has been very supportive of the Rome Statute system. And so each time the 6 pretrial chambers, right, that have been asked to rule on this issue all said the same thing, which is that al-Bashir is not, that the state party, not a non-state party, right, that the state party, whether it's Malawi or the Congo or some other country, have to render the al-Bashir to the court under their obligations of cooperation with the ICC. So they don't really speak to the non-state party issue. They speak only to the state party issue, and it's been all right. So I haven't really seen them refuse to engage. I think it's more they feel that the question of the court's jurisdiction is one for elaboration by chambers, not really politically by the ASP. Yeah.
And I agree 100%. I would just add that whenever an issue like this is presented to the Assembly of States Parties, you really do have a block of the European Union nations and the Latin American nations that stand for precisely what Laila just described. And there may be an AU effort as well as a non-party state effort to try to torque the system through the assembly. But my experience in listening, Laila, to these assemblies as well, is that the Europeans and the Latin Americans generally just are not that interested in going down that path.
Latin America, maybe even more. Yeah.
Well, if I mean that's wonderful that we had this back and forth. Now back to the Jordan, the al-Bashir, Jordan appeal judgment. I'm going to go back to Professor Haque and just ask him that for the benefit of our audience, if you could just briefly summarize the case, what happened, and then just tell us what your thoughts are on whether the court was correct or not.
Of course. So as quickly as I can, in 2005, the UN Security Council referred the situation in Darfur to the ICC. And in 2009 and 2010, the ICC issued arrest warrants for Omar al-Bashir, who was then president of Sudan. And these allegations were incredibly serious. They involved war crimes, crimes against humanity, and genocide. They included murder, rape, torture, forcible transfer. In 2017, al-Bashir, still president, visited Jordan, which is a state party to the Rome Statute, and Jordan did not arrest him. Jordan defended its non-compliance with the court's request, which is a binding obligation on Jordan, on the grounds that al-Bashir enjoyed immunity under customary international law, and importantly, that this immunity was not displaced by the Security Council referral. And so finally, in 2019, the appeals chamber found that heads of state enjoy no immunity under customary international law from arrest and surrender to an international court. And therefore, there was no immunity for the Security Council referral to displace, as Professor Sadat noted earlier. So I agree with the judgment. I think the court was right to place the burden of proof on Jordan to justify its non-compliance with the court's request. By establishing that there really was a conflicting obligation under customary international law. And I agree that Jordan didn't carry that burden. I don't think state practice establishes that head of state immunity applies in such cases when an international court requests the arrest. And the state practice that exists is not widespread, consistent, or representative. And I'm happy to elaborate on that if people want. But I also don't think that we can deduce from the types of normative considerations that Professor Wuerth was discussing from the purpose or function of head of state immunity that it does apply in these cases. And finally, while I generally do not like to infer custom from silence, the lack of reaction from the vast majority of ICC states parties is very hard to ignore and does suggest that the court got it right.
Because this is such an important case and such an important issue, before we move on, I wanted to invite all our other panelists if they would like to also weigh in.
Does anyone think the court got it wrong?
Can I just add maybe build on what Adil said. What was very interesting is I was actually attending meetings of the International Law Commission the day that the Jordan decision came down. And so there had been many members of the ILC, going back to Ingrid's point about their work on immunity. There have been several members of the International Law Commission who themselves had actually submitted made amicus submissions. Sir Michael Wood did, Sean Murphy, Charles Jallow, Mahmoud Hammoud didn't, but he was Jordan's representative to the International Law Commission. So the decision came down. Diri Tladi actually was another one from South Africa. And so when the decision came down, there was a huge discussion, as one can imagine, in the little cafe in Geneva. And I might have been the only one, other than my colleague from Argentina, who was with me saying, yay, ICC did a really great job. And they were very distressed. And Jordan actually was, I think, fairly happy because one of the things that the court did, which I think was slightly Solomonic in terms of what the appeals chamber did, is it decided not to refer Jordan to the Security Council for non-compliance. And I think that sort of saved Jordan from being too upset with the decision. They really weren't actually that upset as far as I could tell. But I had argued, and this goes back to Adil's point about the Assembly of States Parties and the legitimacy. My argument has always been that this is the customary international law and that the states arguing to change this are actually trying to change existing customary international law. And so my argument was a little bit turning your argument on its head, Adil, was that you can't do that by judicial fiat. You've got to go back to the Assembly of States Parties and actually amend Article 27 to put in all the exemptions that you want. If you think heads of state should be exempt, and that states should have to bear the political cost of announcing to the world that they believe in immunity. And I can see that states would not want to do that, actually. And so to me, the sort of anger at the court, and there was a lot of negative blogosphere stuff about the al-Bashir decision, which to my mind was unsurprising and clearly correct. And the fact that that there's so much negativity, it strikes me as slightly disingenuous, because such an important issue like this, if they really believe that this should be the new rule, you have to go back to the state parties and you have to amend the Rome Statute to put that in. Now, I'm not sure they can do that, because I think these are jus cogens crimes. And that gets to a very interesting intersection with Ingrid's point. I don't think universal jurisdiction, audere ad judicare, and immunity are all that separate. This is a discussion point at the ILC, where the ILC has tried to parse these out as very separate inquiries. I think, and you have to forgive me, I learned that Basuni's knee, basically, they're all part and parcel of being a jus cogens crime. And if you have a jus cogens crime, that means you don't have immunity. There is a customary international law rule of audere ad judicare, right? Lots of things go along with a jus cogens crime under international law. And I think that is something that needs to come back and be discussed a little bit more deeply, because this discussion has not gone away, right?
Can I suggest a slightly weaker version of that argument? So one of the legal consequences of peremptory norms is that states are supposed to cooperate through lawful means, right, to bring them to an end, to bring violations to an end. If you think about the lawmaking process itself, the process by which customary international law is made as one of those lawful means by which you can prevent violations of peremptory norms, I would argue that there is an obligation on states to actually modify customary international law to enable the prosecution of international crimes, even if you think at this moment such immunity might exist or is in a state of flux or whatever. Even if you believe that, I think states would actually be under an obligation to modify the law in this regard. So sort of a softer version of.
No, that's a great suggestion. Yeah.
I'm gonna.
If you don't mind, that I thought was really, really interesting between one of Professor Sadat's first points and one of Professor Wuerth's first points. So Professor Sadat pointed out that a key move in the al-Bashir judgment was to say, it's not that international law withdraws immunity in these cases or makes an exception from immunity in these cases. There was no immunity at all. This is critical, because as Professor Wuerth pointed out in the context of draft Article 7, which is about functional immunity, right? There's controversy right? States seem divided. Well, then it really matters whether you think the immunity exists and you need to establish an exception, or you think there's no immunity and you need to establish immunity. The controversy cuts in completely different ways, depending on how you think about that kind of fundamental issue. So I thought that was a really interesting connection between those two things.
Great. Thank you very much. Because we are getting down to our last few minutes, I'm going to take the prerogative of sort of combining the last couple of questions. I'm going to ask first Professor Sheffer, Professor Sadat to address this, and then open it up to the entire panel for any final thoughts you might have. So the question is, first, should there be any difference in regards to head of state immunity and the ICC for states parties versus non-state parties? And then a second question is, what do you see the future of head of state immunity being? So two separate questions, and you can focus on one versus the other if you prefer. So Professor Sheffer, maybe I'll ask you to go first.
Yeah, I'll go as quickly as I can. I think on the latter part, head of state immunity must continue in some respect. I think what our focus has been is on the commission of atrocity crimes. It's such an egregious jus cogens reality to cordon off that zone of accountability and not permit it to be classified as part of head of state of immunity. That, as I said, I think the days of head of state immunity for atrocity crimes are limited, and they're certainly very limited in terms of the jurisdiction of international courts with respect to those crimes and those top officials who are engaged in it, and thus fall, and when they fall within the jurisdiction of the international court in question. I do believe that, you know, we have some rough waters ahead, particularly at the ICC. If certain situations which are under investigation at the ICC tend to move forward very aggressively at this point, and I include within that the Rohingya case, the Ukraine case, or situations, I should say, the situations, the Palestinian situation, the Afghan situation. These all involve non-party states as potential targets of burping up, shall we say, heads of state or other leaders into the jurisdiction of the court. And that'll be extremely controversial. I would just say this. I think it's very much a reality that if that occurs and the jurisdiction of the court seeks to reach those officials of non-party states, it may become a reality that those individuals simply should not be traveling to the jurisdiction of state parties, that state parties should not be inviting those officials to their territory. We live in a Zoom world now. Let's have a Zoom meeting. You don't need to fly onto my territory. If we have a Zoom meeting, I will not arrest you. Thank you very much. Let's get to work. So those kind of realities may evolve.
Professor Sadat?
I think that's really interesting. You know, I completely agree with David Sheffer on this issue that the situations where al-Bashir doesn't raise it because you had a Security Council referral. And whatever you think of the Security Council's power and what it's actually doing, that sort of put to rest the question of whether Sudan had any obligation to comply. I personally differ on the theoretical basis of the council's power to order Sudanese officials or Sudan to comply. I think the council is enforcing existing international law. I don't think it can make international law. I've seen that to the contrary. But I think in the al-Bashir case, you don't really have that problem. In the Rohingya case, let's take the one where we're not upsetting a superpower just for argument's sake. That one is very interesting because the ICC extension of its jurisdiction is based on a sort of an analogy from the national to the international, looking at Lotus and saying, well, the effects of the Myanmar's leadership crime on the Rohingya is to drive them over to Bangladesh, which is a state party. And so there, I think the ICC has jurisdiction, but the political context is much more fraught if it is going to exercise the full complement of that jurisdiction, because you don't have the Security Council referral. And it's clear that Myanmar thinks it's staying out of the ICC's ambit by not ratifying the ICC statute. The other case that I think is interesting, none of us have talked about Venezuela. I mean, Venezuela is fascinating. You know, the US has a criminal indictment out for Maduro. Now, why the United States of America thinks he doesn't have, well, I know why they think he doesn't have immunity, but one could argue that was slightly hypocritical when you listen to Secretary Pompeo talk about immunity with respect to the Afghan situation. I don't know, maybe Ingrid, this one is for you perhaps, but that's why I suggest there's a certain built into this criticism of the ICC's jurisdiction and all these mechanisms is maybe it's like implicit bias, right? But there's this argument that we just don't trust the forum. We don't think the forum is legitimate. We don't trust, and yet, you know, the court has it's had maybe too many acquittals. I work for OTP sometimes, but you know, the court, I think, has proved itself pretty stable. But I do think there's a certain degree of hypocrisy when one looks at assertions of immunity, because the U.S. has often extended its criminal jurisdiction extraterritorial, whether it's Noriega or Maduro, or even in a prior Venezuelan case. So maybe Ingrid has some thoughts about that one.
And Professor Wuerth, if I could ask you to say any final thoughts in a minute or a minute and a half, and then we'll give Professor Haque an opportunity, and that will be the extent of our panel.
That leaves me very little time and a very large number of topics. I just want to pull the thread that's woven through now a number of people's comments about the relationship between universal jurisdiction, immunity, and jus cogens. Some of the arguments that you referred to would apply equally to prosecutions in foreign domestic courts. So, once we begin pulling out that thread, again, some of the arguments might be limited to international criminal tribunals, but a lot of them would function and have been advanced very aggressively in the context of foreign domestic prosecutions, and their Zoom notwithstanding, I think the reasons to have strong immunity regimes, I think there are some really important normative values that are being protected there. I don't think every country is a great fora to try every international crime. And I think immunity is one of the doctrines that helps us wade through that. So the sweeping aside of all of these doctrines opens a large space. I would also just say, the jurisdictional immunities of the state case, the International Court of Justice just flatly rejected this jus cogens immunity argument, and the arrest warrant case drew a strong distinction between universal jurisdiction and immunity. Again, both cases are ones that deal with foreign domestic courts. But I just want to repeat that the arguments that are being advanced here go far beyond the jurisdiction of the ICJ and the ICC, and as appealing as they might sound for some of these particular cases, I do think it makes a lot of sense to think about where they lead doctrinally. So my time's way over, and I didn't even. So Adil, it's up to you. Go ahead. Sorry.
Sure. Just a couple of reactions. So first, we began by hearing Professor Sadat and Sheffer talk about the values underlying accountability for heads of state. We talk about accountability. We talk about deterrence. One thing we also sometimes talk about is the expression of values. And I think one of the values that gets expressed when a head of state who is suspected of international crimes is free to travel is that when push comes to shove, international law takes the side of the powerful. And so if instead they have to do some Zoom meetings, as Professor Sheffer suggested, perhaps that would be appropriate. The other thought I had is something in reaction to something that Professor Sadat said. It's something I sometimes talk about in terms of the cost of error. So if a court is unsure what to do, which wrong decision is the less costly? And I think that in the al-Bashir case, that is what the appeals court did, partly for the reason that Professor Sadat indicated that if states really objected to it, you would expect them to say so and amend the ICC statute accordingly, because the obligations that come under the al-Bashir judgment are quite significant. That if the court says, arrest this head of state, all of you must comply. So if they really objected to that, they could amend the statute. They're not moving to amend the statute, maybe they don't object too much. And the last thought, maybe as a response to Professor Wuerth. So the arrest warrant decision came at the worst possible time, because it came in the early 2000s, right? Just as the ICC was getting off the ground, and the very possibility that heads of state, foreign ministers might be under an indictment from an international court that might seek arrest by states parties and so on. That possibility was just opening up. And then the arrest warrant decision comes down and says, no, absolute immunity from foreign domestic jurisdiction. One of the, I think, beneficial things about the al-Bashir judgment is that it does not close that door. And now we get to see how states react. And if states really believe that head of state immunity is that important, then they will stick to their guns and they won't comply in future cases. But if they don't, if they think actually accountability is more important and when push comes to shove, international law should be on the side of justice, then they can go down that road instead. And the al-Bashir judgment leaves that door open. And I think that is another mark in its favor.
Well, on that note, I'm afraid we have to end this. Thank you so much for a great discussion on this topic. I found it very interesting. I learned a lot, and I'm sure that the rest of the attendees at the conference did as well. So, Milena, did you have any final thoughts?
Thank you for your comments. This was a wonderful panel, and I hope our audience enjoys it as much as Andrew and I did.
Thank you.
Again.
Thank you very much.
Thank you.